On August 4th, 2014, disaster struck at Mount Polley Mine. Polley Mine is in interior BC, located 65 kilometers northeast of Williams Lake. It's close to Polley Lake and Quenzel Lake, which both drain into the Fraser River. Mount Polley Mining Corporation operated the mine under its parent company Imperial Metals. The mine was an open-pit copper and gold mine which began operation in 1997 until a failure in the tailings storage facility's embankment walls on August 4, 2014 caused a halt to operations. It had a 4-kilometer squared tailings pond for containment of the mill waste effluent and runoff from the mine. Its embankment reached 50 meters high and was engineered by consultants from outside the Mount Polley Mine Corporation, which consisted of 3 people over its lifetime. Knight Pieshold, who was there for the feasibility of design stage through to the 2011, and then Foster Wheeler from AMEC, who took over in 2011 and was the engineer on record for the time of the breach. The breach occurred when the dam enclosing the tailings storage facility failed and released over 21 million cubic meters of water and tailings into the Quenzel and Fraser River watersheds. Likely BC and the surrounding areas and communities were put into a state of emergency, and boil water advisories were put into effect. An investigation in December 2015 conducted by the Chief Inspector of Mines found that the dam failure was due to the embankment sliding over a layer of over-consolidated glacier-lacustrine clay, approximately 10 meters into the dam's foundation. This portion of the foundation had not been properly characterized by the Mount Polley Mine Corporation or the hired engineers. The strength of the glacier-lacustrine clay was overestimated compared to the native soils, meaning it was not strong enough to handle the pressure. There were other factors leading to the dam failure as well, including the downstream slope of the dam was too steep for the height that it was. An unfilled excavation was located at the bottom of the outside of the embankment, and there was more supernatant water in the tailings facility than expected. As you can imagine, this event made headlines and multiple lawsuits were soon placed against multiple different parties. The first lawsuit was launched by Imperial Metals in July 2016 against the engineers on record for the dam. This suit claimed that the failure was due to flawed mine designs by the engineering companies, which the defendant companies swiftly denied by launching countersuits against the third-party engineering companies, the provincial government, and the mining companies. The next lawsuits launched were by representatives of multiple Indigenous bands and communities in the area against Imperial Metals and associated companies. 3 separate lawsuits were filed seeking damages for harm to their rights and interests, which included fishing rights. These looked to provide justice to the affected communities and deliver a message to the province and mining industry to design, operate, and oversee mines that are in line with Canada's human rights obligations. In October 2016, Mining Watch Canada launched a private prosecution against Imperial Metals and the provincial government for violation of the Fishery Act regarding the 2014 dam failure. Let's take a deeper look into these court proceedings. Imperial Metals launched an action in breach of contract, negligence, and negligent misrepresentation against the engineers on record. The plaintiffs alleged the tailings facility was designed and monitored by Knight Pieshold and AMEC throughout its entire lifetime, and that Mount Polley Mine Corporation constructed and operated the tailings facility with the defendant's design and instruction. The individual engineering companies responded with denial to the plaintiffs' claims and pointed the finger at each other, the mining companies, and third parties. These third parties included the province of BC and BCG, which was the engineering firm taking over engineering responsibility from AMEC at the time of the dam failure. Counterclaims filed by the defending engineering companies were against Mount Polley Mining Corporation and associated mining companies for negligence, breach of duty, breach of obligation, and failure to monitor and report mining operations. The defendants relied on clauses in contract that exclude and limit their liability to the event. Chief Anne Louis on behalf of the Williams Lake First Nations Band and Chief Donna Dixon on behalf of the Soda Creek First Nations Band filed against the owners and operators of Mount Polley Mine and the province of BC. Action was launched in nuisance, trespass, public nuisance, negligence under strict liability against corporate defendants, and negligence against the province. Allegations from the plaintiffs were that the breach of the tailings storage facility dam was caused by deficiency in the construction and operation of the dam and mining facility, which resulted in the release of harmful substances into their traditional territories. The plaintiffs claimed that the mine was not managed adequately and the mine design was not followed. They also alleged that the province did not meet the reasonable standards of inspection and regulation of the mine. The Stat Lium Chiefs Council, on behalf of the Stat Lium v. Mount Polley Mining Corporation, was a lawsuit that was filed by a conglomerate of Indigenous chiefs representing their bands against the owners and operators of Mount Polley Mine and the provincial government. The plaintiffs had similar claims to those made by the plaintiffs in the Louis Chief v. Mount Polley Mining Corporation suit, adding that the release of harmful substances stretched to throughout the Fraser River watershed. The Silcotin National Government, Bernie Elkins and Francis Lacey's, on behalf of the Silcotin and the Tusi First Nations bands, filed against the owners of Mount Polley Mine, the engineers on record for Polley Mine, and the province of British Columbia. The actions against the mining companies were in private nuisance, public nuisance, and negligence under the Fishery Act and a strict liability rule. The action against the engineers on record and the province were in negligence under the Fishery Act, which alleged the breach of the tailings storage facility led to the release of deleterious substances into the Fraser River watershed. According to the plaintiffs, the breach was caused by flawed construction and operation of the dam and facility and other mining operations. Management of the mine was not adequate, and the province failed to meet the standards of inspection and regulation of the mine. It was alleged there was a failure by the Ministry of Energy and Mines to require the mining companies and engineers on record to operate and construct the mine in accordance to the design requirements. Hugo Lapointe of Mining Watch Canada accused Mount Polley Mining Corporation and the province of violation of sections 35 and 36 of the Fishery Act. These sections state the prohibition of serious harm to fish and the deposition of deleterious substances into fish-bearing waters that sustain commercial, recreational, or aboriginal fisheries. The accuser claimed that through negligence of both Mount Polley Mine Corporation and the province, the spill occurred, and raised concerns that the Crown had not laid any charges through the enforcement of the Fisheries Act. These charges were stayed by the federal prosecutor, who stated that there was no reasonable prospect of conviction against the two accused from the evidence shown in court by Mining Watch Canada. To this day, there have been no charges or fines for the dam breach at Mount Polley Mine. The incident has brought attention and public scrutiny to professional reliance models. The lawsuits and prosecution of the mining companies, engineers on record, and the province have only increased this scrutiny. No one has been determined to be at fault, and everyone involved is still playing the blame game. Monitoring, compliance, and enforcement are thought to be a pillar in professional reliance models, and measures put in place by the mine following the dam failure built the pillar for Mount Polley. Prior to the failure, there were allegations made towards the mining companies that there was inadequate monitoring, compliance, and enforcement of the tailings storage facility. There was the duty of the companies and province to comply with regulations for design and use of the mine, and it appears due to the disaster and investigations afterward that what was done was insufficient. After Mount Polley, a new obligation was added to the Mining Act Code requiring the engineer on record to report unresolved safety issues in a timely fashion. The Haddock Report on the Review of Professional Reliance recommended multiple changes to the Mines Act to make professional reliance more reliable. The event at Mount Polley Mine and continued court proceedings that followed made the public question professional reliance and its actual meaning. There is expectation that professionals are accountable and responsible for the decisions they make, and as there have still been no charges or fines against any parties 8 years on, the question of trust comes up.